Hello, everyone. I'm the Apple Watson, founder of Modern Family Law Help for You Group, Alienated Dads Network, and the Mackenzie Friend official store. I'm here to talk to you today, like a human, that's what I am, about non-molestation orders in family. So I've been watching quite a few videos, and I'm trying to get better at them. But I've noticed something with all these family law ones, is they're all quite rah. I get that we're going through traumatic and painful experiences, right? But it doesn't have to be this way. Right. We'll talk more about that in another video. Still, this video is about you, and just like you, many of you, I'm just a parent who's been dragged through the family court system more times than I care to remember. Less about me, more about you. This is about you and how you can fight back and find yourself with a malicious non-molestation order. Before we dive in, like I say, a quick disclaimer. I've had some trolls trolling me as I do. And I just need to say that I'm not a solicitor as yet. I've not passed my BLs in law just yet. I'm not a psychiatrist. I'm not a social worker, although I'm very good at all of these things. And this is not legal advice. This is just guidance based on my extensive research and professional advice I've been receiving, of my own lived experience, and of course, thousands of cases that I've studied and supported on. If you still need to make your own decisions after all of this, it might be possible to get legal advice, though many of you may not be able to afford it. You don't qualify for legal aid, do you? No, you don't. Let's get into it. The truth about non-molestation orders is, first things first, what exactly is a non-molestation order? It was supposed to be a shield, a protection for people facing real threats, real abuse, and real danger. Where that's genuine, and it really is the case, I fully support it. It works really well. But here's the problem. These orders are now being weaponized as a tactical tool in family court battles, particularly in child arrangement disputes. And why is that? Well, two main reasons. Block contact with your children. If one parent wants to alienate the other, slapping a non-molestation order on them is a perfect excuse to cut contact. And two, to access legal aid. The moment someone claims domestic abuse, true or not, they qualify for legal aid, meaning their legal costs are completely covered by the government. And guess what? It's even better for them. Even when and if their allegations later turn out to be completely false and made up, the system doesn't punish them for lying. And here's the truth. When legal aid was removed for most family court cases, non-molestation order applications suddenly skyrocketed. Coincidence? I don't think there's anything such as a coincidence in this world. The result, good parents, mostly dads, but sometimes mums too, are being falsely accused, cut out of their children's lives, and forced into a long, expensive, soul-destroying battle to prove their innocence. And the worst part, like I said a moment ago, there's no consequences for making false allegations. So if this happens to you, here's what you need to know. The non-molestation order can be applied for in two ways. And without notice, which is ex parte, these applications, well, this is where they start to get really nasty. The applicant doesn't even have to tell you they're making the application. The judge hears only their side of the story. If the order is granted, which generally it would be, you immediately have restrictions placed on you without ever getting a chance to defend yourself. If you breach the order, straight into prison, no questions asked. The next option is you have a with notice application. Less common, but I say less common, more common these days than what they were about 18 months ago, but slightly fairer. You get a copy of the application, the statement and evidence, usually a few days before the hearing. You need to find yourself a really good Mackenzie friend to get you prepared for that. Wink, wink, nudge, nudge. You actually get to attend court this one though, and argue your case, but it's not as straightforward as that. Let's talk about what to do when you find yourself hit with one of these orders. I think the most important thing to do, the first thing you need to do is remember this. Breathe. Just breathe. Take a moment and breathe. I get it. You're shocked, angry, and panicking, but take a deep breath. You need to clear your mind and fight this properly. Read everything carefully. Go through every allegation in the statement. Take notes and look for contradictions, false claims, or twisted versions of the truth. Decide whether to contest it. This is option 3. If the allegations are true and relevant, then maybe the order is justified. Own your shit and don't contest it. But if they're false, exaggerated, or irrelevant, you must contest it. Otherwise, it could seriously damage your chances of seeing your children. Now, there's a process to this. And not everyone gets it right, in my view. And this is where people need to know the difference between me giving you advice and everyone else. The court process is what you'd expect from the first hearing. The judge asks you if you're going to contest the order. If you don't contest the order, it will likely be granted immediately. If you do contest the order, the court will set a timetable for evidence gathering. You'll gather your evidence, police reports, request full police disclosures. False accusers often slip up when the police statements arrive. School report records ask the judge to order your child protection plan. If you're on the child protection plan, the likelihood is you could be, or a child in need plan. There will be sometimes a Scott schedule if there's many allegations against each other. It's a document that's breaking down the allegations into the table, and then you'll get made to the top 5 allegations are proven false. It weakens the entire case, but generally, in my experience, it's not always you're going to get allegations proven false. I mean, in most cases, you'll actually find that the judge's prerogative is to make sure that something does distinguish. You'll then go to a dispute resolution hearing, which is a chance to settle the case before going to trial. Then you go to a final hearing, and if no agreement is reached, this is where the judge hears all the evidence and makes the final decision. Expect to be cross-examined and expect to challenge your accuser. Taking an undertaking with no findings and combining a non-molestation order with a child arrangements order, however, is another option. Let me just get this straight. Let me just be clear with you on this, right? This first contested hearing, when you go to, is generally 15 minutes, 30 minutes long. In my view, you're not asked to take a statement to court with you. You're not asked to do that. You're not asked to do anything. You're asked to go to court, and then in court, the judge will ask you if you are agreeing with the order, disagreeing with the order, or accepting it. Just say all those things. In amongst doing this, I believe, and this is what I do for my people, you need to prepare your statement. Lock, stock, 2 smoking barrels, fire it all in. You may only have 48 hours to do it. You may only have 24 hours to do it. You might only have 12 hours to do it. But you need to find yourself a very good Mackenzie friend who will support you doing that. You go to court, all guns blazing. Yeah, you get your statement in as soon as you can. If you have to take paper copies in, you take your paper copies in. You put everything in there. The judge won't have time to go through all. They won't go through all the evidence. They won't go through everything at all. They won't. It's not the right hearing for that. But they will see it. They'll look over it. They will look over it. You expect them to look over it. And if you've got enough evidence in there to shed question marks in the judge's head, and you can present all that, and you present it well yourself, and you're doing all the right stuff, and you're saying all the right stuff, and it just so happens by coincidence that a few weeks before the non-molestation order application has gone in, child arrangements application has gone in. Doesn't matter if it hasn't. You could have made them aware that you were making the application. And by the time this court hearing is happening now with the NMO, you need to have made your application. You need to have made your child arrangements application. That's vital. Now, if the allegations are serious and they're of a sexual nature or a physical nature, and they provided evidence of bruising enough to raise alarm bells, then what I'm about to suggest probably won't be accepted. There are a few times where these sexual allegations have been included and they've been accepted as this go through this next step, taking an undertaking. Because what you do is you are going to request that you do an undertaking with no findings. You understand that these allegations are going to have to be heard anyway. You make clear your argument that this is manipulation of the system. A lot of people will say you don't have to do the statement at this point. I say different. You get the statement in, or you get part of the statement in. You get your argument in at least, because you're going to have 15 minutes, half an hour to try and explain everything, and you're going to forget your words, and you may get cut straight out. You may not give them time of day. Don't forget, it's innocent until proven guilty in any other world. In family court, as a man, you're guilty and you have to prove yourself innocent. That's right. You're guilty and you have to prove yourself innocent. People will say different, but that's not the case. I used to ask any man how they feel, and then they'll tell you. If you are taking an undertaking But you need to try and pitch it, is what you've got to try and do. And you need to try and combine this non-molestation application with the child arrangements application. If you're dealing with a non-molestation order, NMO, in family court, and considering giving an undertaking with no findings, or if you want to combine the NMO with child arrangements proceedings, this is how the process will generally. Stick with me on this. What I'm about to tell you is how do you take an undertaking with no findings? How do you combine a non-molestation order with child arrangements order? If you're in family court system, this could be a huge difference in your case. Let me just be clear on that, yeah? So stay with me. It's going to save you time. It's going to save you time, a lot of time. But before we dive in, another quick disclaimer. I need to remind you, because the trolls are trolling me, this is not legal advice. I'm not a solicitor as yet. I've got 18 months left on my BA honours in law. And I'm not a psychiatrist and I'm not a social worker, but I'm fucking good at what I do. And this is just guidance based on research, experience, and real cases that I've dealt with and case law history. Always seek your own legal advice if you can get your legal aid or if you can afford it. If you can't, Modern Family Law Help for You group, and where you can get more of this information exactly like this. So what do you do if there's an undertaking with no findings? So first up, what is an undertaking with no findings? An undertaking is basically a formal promise to the court. You agree to certain restrictions, like not contacting your ex or going near their home, but without admitting guilt and without the court making any findings against you. Now, why would you take this undertaking instead of fighting the non-molestation order? Come on now. There are so many advantages, big advantages. There's no admissions of wrongdoing. You're not saying that allegations are true. There's no formal findings against you, so it won't impact automatically the future cases. It avoids a contested final hearing, so it cuts time out of this non-molestation. This 18 months, 2 years non-molestation will take, which could go badly if judges rules against you. There's less impact on the child arrangements because, like I say, because an undertaking carries less weight in the formal than a formal non-molestation order. But before you rush into accepting one, there are some things you need to watch out for. And these are very important. Undertaking can't be used in cases where the court thinks there's a real risk of harm. In those cases, they'll insist that the non-molestation order needs to be looked into. Breaching an undertaking isn't a criminal offence like breaching an NMO. You can still face contempt of court. Right, so if you decide to take an undertaking, how does the process work? How are you going to fit this in? Because the judges don't always come out and tell you about it, and neither will the other side solicitors. So how to give an undertaking in court. 1, negotiation. Prepare your statement, give a full picture of everything, of what you experienced. Your first hearing is like 15 minutes half. If you're stupid enough to pay for a solicitor, your solicitor can offer an undertaking instead of contesting the NMO for you. If you're litigating in person, which I think you should be, then you let the judge lead. And then the judge will suggest the way forward, tell you, do you want to do this, do you want to do that? And then if you can't agree, if both sides can't agree, then you suggest it to the judge. You can't take an undertaking, with no findings. Explain your argument, explain why you think that this is a manipulation of the system in court. That's to prove it. The judge will ask you to confirm that you understand what you're agreeing to. If he doesn't see there's a proper risk, and if you've pitched everything properly and you've done enough work in terms of your statement, then they will approve the non-molestation, the undertaking with no findings. That then saves you like 18 months. And you can go straight into your child arrangements. You're then moving forward with your child arrangements. Well, that's sort of back burner. But the allegations will still have to be heard. Those be heard in your child arrangements as opposed to being heard in the non-molestation application. The judge will ask you to confirm what you understand that you're agreeing to, should it be accepted. They'll also remind you that if you breach it, you could still be brought back to court. But again, it's not a criminal offence like breaching of the non-molestation order. Formalising the undertaking. Once agreed, the undertaking is recorded in a court document and replaces the NMO application. If you breach it, your ex has to take you back to court rather than just calling the police. So that's how you can take an undertaking, but with no findings. But let's talk about something else. This is important. What if you also have a child arrangements? And what about if you put your child arrangements application in and you've combined the two? Why would you want to combine the two? Combining an NMO with a child arrangements, it's genius. Because if it say again, you can hear them both together. The allegations can be heard as one. So rather than hear the allegations in the non-molestation application and then have to go through the whole thing again with the child arrangements, it makes more sense just to put them all together and hear it as one. It's going to have the same outcome with your children. It's going to be found allegations upheld or not. Now this is where it gets really messy, because if there's a non-molestation order against you, it can have a huge consequence on the child arrangements case, because the family courts prioritize child safety. And even if the allegations are false, the court may still limit your contact just to be safe. But here's the good news. A non-molestation order does not mean automatic no contact with your child. If you're in a situation, if you have like three main options, you can, like I say, challenge the NMO first of all. If the NMO is based on false allegations, fight it before your child arrangements case. Or combine the two. This is where you combine the two. Yeah, it moves forward together rather than having the working through the non-mol with your child arrangements being stagnant. That makes sense. You always apply for the child arrangements. Your child arrangements is the most important thing. Even if you have the NMO running in separately, you can still have them running separately. I'm going to call it that sooner or later, someone somewhere is going to see some sense and combine the two of them together, because it just makes sense. The court will balance the NMO against your child's best interests, which usually means contact should still happen in some form. There won't be any contact going on until the final facts hearing has happened. So when I say some form, it'll be indirect contact or contact center. If you take an undertaking with no findings, however, it removes the legal weight of the NMO, don't forget. This can help you in the child arrangements case because there are no formal findings against you. So how do you actually combine the two cases in court? Oh, like I said, always suggest it, always suggest it. Judges won't like that you suggested it because they never thought of it first. People won't like that you suggested it because they never thought of it first. But here's what you need to do. 1, inform the court about the child arrangements. If you've already in the NMO proceedings, tell the judge you've also applied for the child arrangements, and the court may still choose to, and sometimes they do. Sometimes they'll say they have to run both side by side, but they'll get to a point where, because it's that messy, we'll get to a point where you have to join them together because it just makes sense. Second step is request a directions hearing. If the NMO is blocking contact, ask for the directions hearing to clarify how the orders interact. This is bullshit, right? This is how it's meant to be, but it's not that way. They won't tell you the way I'm telling you to do it. If you've got NMO on you, you make your child arrangements application, and then they work around it. It saves so much time. Yeah. If the NMO is granted, ask the court to allow the child-related communications for school, emails, etc. Don't let it get granted. It won't get granted. You take an undertaking with no findings unless there's serious allegations, in which case you combine the two, because you submit your child arrangements application and you tell the courts that you submit your child arrangements application. It makes sense to hear them both together. You have to be logical with this stuff, yeah? Show that you're cooperating, that you respect the court orders, and that you're focusing on your child's best interest, because that's what you're doing. So an undertaking with no findings can help you avoid a damaging NMO. Having an NMO doesn't mean you lose child contact forever. It does mean you have to jump through a few more hoops of fire and be very self-aware. I can guide you through that stuff. I can help you through that stuff, but it's not easy. Not easy for you, at least, anyway. Because we're making decisions that you don't want to make and doing things you probably don't want to do and you don't agree with. But you need to be proactive. You need to stay calm. You need to fight smart. If you found anything that I said useful, do me a favor, like, share, and subscribe. If you're a troll and you have nothing nice to say, then I was about saying nothing at all, because I'm quite comfortable with the thought, knowing that I open up people, doing what I do. So yeah, if you're a troll, get a life. If not, visit Alienated Dad, the Alienated Dads Network on Facebook group. There's a link down there for a membership group where you get all the indirect support that you need for £97 a month. Don't forget, just don't give up. Fighting false allegations isn't just about clearing your name. It's about protecting your right to be in your child's life. If you need more help, if you're dealing with similar situations, drop questions or comments in the box below. And I'll see if I can answer as much as I can. Stay focused, stay strong, and don't give up on your kids. Till next time, peace and love.